Hello, everyone. It's your host, Brian Hunt, and welcome to another brand new episode of Risk On, Risk Off. This is our first episode of the new year, and very looking forward to having this following guest on. For many of you know who I do these shows, we have a heavy concentration on obviously risk, but with a heavy focus maybe on construction and commercial real estate. And with my background is in risk assurance and brokerage. I deal a lot with my clients to help them make sure they've got the most efficient use of their insurance and make sure their programs are sufficient to cover their needs. But what we've been seeing in the insurance market is a sort of pretty steady escalation in insurance rates for certain types of occupancy, especially transit, shipping, as far as truckers are concerned. And construction is seeing some upward pressure as well, because what we're seeing in this marketplace is a pretty constant upward arrow with respects to claims and judgments. And some of these judgments are really starting to get massive. As an example, for some people you might know, here in construction world in Dallas a couple years ago, a crane fell over during a construction project to a high wind and fell over onto an apartment complex. And unfortunately, during that process, killed a young woman who was sitting in a room in her apartment watching TV, sitting on her sofa. And obviously went to trial. All this is very public knowledge, and a judgment of excess about $700 million was awarded against the construction firm and the general contractor, developer slash, because all one entity. Massive amount. I mean, that is a massive amount of money. And these numbers just seem to keep on going. And it's getting difficult to the point for some places to even justify buying insurance. And therefore, even do I want to keep doing this because it's so expensive? So I recently had the good fortune of being on a panel at a conference in Las Vegas where I was asked to be on a talk about nuclear verdicts. And I had this couple of attorneys. Well, I'm not an attorney, but some attorneys were on the show, on the panel, talking about what they're seeing in this world of nuclear verdicts. And I was just, this particular guest we're about to have here is really knowledgeable and had a great story to tell. I really wanted her on the show because this is of a particular interest to a lot of my clients and people in the industry. And so I was very excited to have and very grateful to introduce Miss Ashley Paige Fetyko. Hey, Ashley, how are you?
Hi, Brian. I'm good. How are you?
Great. Thank you so much for jumping on the show. And, you're the first episode of the new year, so I'm glad to have you here.
I'm glad to kick it off. And you got my last name right, so you nailed it.
Well, thank you. I try to be prepared and I try to be diligent. So awesome. Well, great, Ash. I mean, obviously, Ashley, you have a great background, and specifically, we're going to talk about nuclear verdicts. But before we, dive into it, I just want to talk a little bit about your background. And you're not probably a little bit younger than me, but maybe you might catch the reference. But if we're playing the game, where in the world is Carmen Sandiego? Where in the world is Ashley right now?
That does seem to be the theme of my life. I'm currently in Denver, but that is going to be short-lived because I'm on the road very frequently, as you know. So yes.
Good. And so are you from Denver originally?
I am born and raised. I'm one of the few, I think, who are actually native. So yeah.
Yeah, it's the same thing when I'm here in Dallas. When I go to events and parties, I say, "Where are you from?" "I'm from Dallas." "Oh, you're the guy." Because there's a whole lot of people from other parts of the country and the world here now. So I think Denver's the same.
Yep.
So obviously you grew up in Denver, and you had an image to leave the city of Denver and go to the East Coast and go to Emerson College. What was sort of the motivation for that?
Yeah, so my family is originally from New York. And so I thought to myself growing up, like, I need to be on the East Coast. That's where all the action is. That's where all the cool stuff is happening. And Denver is really like a booming place now, but that wasn't always the case. And so I was very propelled to kind of spread my wings and get out of Dodge, so to speak. And so on a college trip, my parents were trying to get me to go to Boston because they lived there. And I was always like very opposed to Boston. I just wanted to be in New York City. But when we were on a college trip, I fell in love with it. And so I decided to go to Emerson College, and I double majored in creative writing and political communication there. So
very nice. And so when you went to Emerson, do you know you're going to be a lawyer, or is it something that sort of stumbled upon later?
No, it was always sort of, I was always a nerd. I say that affectionately to my fellow nerds. But I always kind of thought I was going to say, I think I'm talking to the right audience here.
Yeah, I think so.
But I always kind of thought that I was going to be a lawyer. I fell in love with, I don't know if did you ever see the TV show, The Practice?
Oh, yeah.
I think it was on like ABC. Yeah,
Mhm.
fabulous show. And so I fell in love with that show when I was a kid. And so I knew that I wanted to be a lawyer. But I have like this really creative streak too. And so I needed to go sow my wild creative writing oats before I did that. So yeah, and I think like pre-law used to be more of a major than it is now. I think now really law schools look for a really diverse background. And so I just kind of landed at Emerson because I knew they had a great writing program, and the political communication was sort of the left brain part of my education. So yeah.
Very good. And so it took you so you started in Denver and you go all the way to Boston, and you head the opposite direction, go west, go to Southwestern Law School, which I always found that name appealing because I went to Southwestern University in Georgetown, Texas. And so no affiliation, but I like the sound of that law school anyway. So
yeah, so after I graduated from undergrad, I knew that I wanted to go to law school, but I wasn't quite ready. Like I was slated to take the LSAT, which is the test you have to take to go to law school. And just the thought of like another 3 years of school, I was like, I can't do this right now. So I kind of bounced around a little bit, and I worked for law firms, which I hated, but it was because I wanted to be a lawyer, not a legal assistant or a paralegal. Yeah. And then I ultimately applied, and I went to Southwestern because they had, and they still do have, a phenomenal trial advocacy honors program, which is a 2 year honors program that's focused just on trial skills and trial advocacy. And I knew that was always going to be my jam. So, so that's really why I went to Southwestern, and I ended up being on the board of governors in that program. And most people hate law school. I loved law school because of that experience. So yeah, I did. Loved it. I told you I was a nerd.
Fair enough.
I already shared this detail. So yeah.
Fair enough. So obviously, looking at your career, I was looking at your profile. It's obviously very distinguished, but you spent a lot of time as a district attorney. And from my understanding, you did a lot of criminal district attorney. Is that correct?
Yes. Yep. So all criminal prosecution. And I spent about 8 years doing that. And I really focused on like the gnarliest crimes. So a lot of murders, a lot of crimes with children, kind of like I don't know why. I was good at the case. And so that was kind of what I fell into. And it's a specialized area to know, how to treat that kind of a sensitive situation. And, the area of law is a little bit more nuanced. So that's what I really focused my time doing while I was a DA.
Yeah, and you and I were chatting. You did it for a while, but I guess, like you said, we were talking offline. Is like you can only go to so many crime scenes and read so many coroner's reports before it kind of gets burnout kicks out eventually. So that being the case,
which sounds so wrong, but after like a certain number of autopsies, I was like, I don't think that most people have this as part of their everyday, and I don't think I need to anymore. So yeah.
No, I don't blame you. I think enough blood after a while. I need something different in my life. Which, about roughly now, for a while, are no longer involved in the world of criminal law, but you're actually heavily involved in the area of nuclear verdicts. And tell me about that sort of transition from what you were doing to doing what you're doing now. What was sort of the motivation?
So I am with Tyson Mendes, and we are really the anti-nuclear verdicts firm. When I was looking to make a transition, I spoke with a couple of the partners of the firm, one of whom I had known for years, just to kind of get a sense of like, what is happening in that world, and is there maybe a place there that might be good for me? And so her name is Casey Lynch. She's our administrative partner. She sent me a copy of Bob Tyson's book, which this is not a plug, but it's just always casually sitting next to me. And it's called Nuclear Verdicts, Defending Justice for All. So I read it just to kind of get a primer to see what is happening in this area of law that is wildly different from what I've spent the past several years doing. And I was really struck by the enormity of this problem. And after reading that book, I started doing a lot of research before I even interviewed at the firm, just on nuclear verdicts and the trends that are happening. And then that led me down the rabbit hole of social innovation. And I think at my core, as I think is probably evidenced from my work as a DA, I believe in justice. You know, I'm very driven by what is fair. And so that the impact of nuclear verdicts on everyday consumers who have no idea what is even happening in courtrooms in their own communities really spoke to me. And so, you know, in talking with the partners at the firm, it became very clear that this is a place that's doing something about it. And we're known for being very innovative and very creative. And as I said, I have that creative kind of wild streak. So it was like, okay, this is the perfect home for me. So my role is now really focused on educating our own attorneys, but then I'm also on faculty for the Nuclear Verdicts Defense Institute, and I speak across the country on nuclear verdicts. I speak to carriers on what's driving them, on what we know can stop them. And so that's really kind of the focus of my practice now, is really largely education and trial skills.
You know, that's a great segue, because I really want to talk to you about, and we'll break this down as far as the past, how do we get to this point, the present, what's driving this, and then the future, to your point, what can be done to stop or mitigate this or bring in some sanity. So first question, and before I even go, guys, if you're sitting here watching the show, please note, if you're on LinkedIn, if you look at the bottom right-hand corner of your monitor, you should see a picture of me, and there's a little oval next to it that says add a comment. If there's a question you want me to bring to Ashley's attention, please go ahead and ask your question right there, and I will press enter, and then I will see it. And as long as you keep it wholesome and clean, I will bring it to Ashley's attention. So this is a family show, guys. Let's keep it clean. so Ashley, let's walk it back. So first of all, what is the definition in your mind of a nuclear verdict?
Yeah, that's a fabulous question. So we define a nuclear verdict as anything in excess of $10 million, or, and this is a really important distinction that I think is often missing in the conversation, it's any verdict where the non-economic damages, so the pain and suffering, are disproportionate to the economic damages and the actual facts and injuries of the case. So any case can be nuclear, even if it's not a $10 million result, if that award is just out of whack with the reality of what happened and what the actual injuries were. Okay.
So let's walk it back, because I mean, I've been doing risk and insurance most of my life, but I mean, it does seem like this sort of mushroom event, or spreading like a fungus, for lack of a better term, has been really increasing rapidly, past 7 years, 8 years. Let's call it like that. When would you say, if you've done a lot of history on this, when would you say this trend started? I mean, was it a certain jurisdiction, a certain trend that was changing in legislators' opinion as far as how this works? I mean, where did this start?
So we have pinpointed the sort of catalyst for where we are now to the year 2009, which is, I think, earlier than most people kind of think of, because the term nuclear verdicts, to your point, I don't think has really gained a lot of traction until more recent years. But two interesting things happened in 2009. So in 2009, the financial crisis was happening. And so insurance companies were just doing everything we could to stay solvent. At the same time that was happening, the plaintiffs' bar released a book, and that book was Reptile. So for those who don't know, the reptile theory is, it's since, I think it has progressed and adapted into multiple new things. But the reptile theory was sort of the name of that book was, the plaintiff's revolution. And it really did revolutionize the way that plaintiffs' counsel tried cases. It prompted them, after years of psychological study to see what actually works and what motivates jurors, it urged plaintiffs' counsel to, historically, they had always gone for sympathy from jurors. They wanted to generate as much sympathy for their client as they possibly could. And now they will still take your sympathy, don't get me wrong, but Reptile and its progeny and other theories like that urge them instead to cultivate juror anger. And so, because anger is a bigger motivator than sympathy.
Yeah, I can see that.
Yeah, so that, and we do a whole deep dive into the psychology of anger at the Nuclear Verdicts Defense Institute, and it is fascinating. It makes absolute sense when we have a psychologist who comes in and actually delivers a full presentation on this. Once you actually hear about the psychology behind why that emotion works, it makes absolute sense. So what happened was the plaintiff's bar went in one direction, which was fueled by psychology and driven by creativity. And the defense bar, who are just responding to what's happening and responding to our clients' needs, we're given litigation guidelines, we're streamlining, we're cutting expenses, we're definitely not spending more money on mock trials or mock jurors to understand what's happening from a psychological perspective. And so I think it's only now that we're starting to catch up, because we're seeing the dramatic effect that these psychological principles that the plaintiff's counsel, the plaintiff's bar has been using actually has on the end result in a courtroom and even in mediation. And we can talk about this too, the fallout from that, which is settlements and just case valuations. So really, we think that 2009 was sort of the catalyst for where we are now, because we went in two wildly different directions, and we're only now starting to catch up to what they have done, which is adapt.
And obviously, you've done a lot more research, and your group's done a lot more research. But one of the things I've laid my side in the insurance world, and things I read from newsletters, whatever the case, or talking to people, the concept of, especially in 2009, the Great Recession, you had massive bailouts for large banks, and no one went to jail, maybe except for one guy, and then a lot of people on the general retail people got hurt substantially. And as a result, there's this sort of like this fear, like concept, like, well, when someone gets onto a juror case, it's almost sort of like this conception of, correct me, it's like, I'm going to help that guy, he's going to get his, like, because it's almost like a vengeance, for lack of a better term, against the big fat cats, as far as taking out on the little guy. Is that a fair assessment as far as part of the factors behind this?
I think so. I mean, I think we often wonder, like, are people just getting angrier in society?
Yeah, and I think that's the case.
I kind of think to some extent, I think to some extent that is happening. But I mean, to your point, that is definitely a contributing factor. And if you think about it, when the plaintiff's counsel is walking in the door, their number one goal, really their only goal, is to get as much money as they possibly can. They are driven by that sole focus. And the way that they're going to do that is to generate anger. If you have folks in the jury box who are already primed for that anger and who want to, fix things for this little guy and really stick it to the man who they perceive to be the man, which is the corporation on the other side of the courtroom, that's a recipe for disaster. There was a study done in 2012 that was a University of Chicago study that was done that analyzed what's called the corporate identity effect, which is essentially analyzing, what happens when corporations are named as defendants in lawsuits. And its findings, I don't need to go too in depth. I mentioned I'm a nerd, right? I won't go too in depth. But the findings really supported the premise that corporations are on the whole viewed as more liable and more owing of higher damages. So they analyzed, under the same fact pattern, what happens when our defendant, it's a fake fact pattern, when our defendant is a sole individual. What happens when our named defendant is ABC Corporation? And what happens when our named defendant is ABC Corporation with information about the CEO or some individual person attributed to it? And what it found was that jurors on the whole awarded much higher damages against just the corporation without any personalization. So I think a factor of that, especially if you look at the timing for when that study came out, 2012, I think that speaks to your point that I think there probably existed and exists probably even more post-COVID, a desire to really punish a corporate defendant, which is not great news for us.
Yeah. So actually, we got a first question, and I know this gentleman very well. So Tim, thanks for sending your question in. And this is maybe, I think I might bring it up now because it's something that's on top of my head. So Tim's asking, do you see plaintiffs taking cases to trial even after being offered policy limits as a settlement? Which is always kind of interesting. And there's a, and I've actually had this conversation with someone today as far as working with a client, as far as, should they, based upon their revenue size and where they are, get an additional $5 million in excess in their tower. And they're kind of thinking is like, well, if we do that, we're almost enticing ourselves to be sued for an additional $5 million if we get pulled into a lawsuit. So that's a good transition. The point of insurance, does it make it more people inclined to sue if they know they've got higher limits, or how do you sort of think about that playing out?
Yeah, that's an interesting question. Thank you, Tim. So we are definitely seeing that. We are absolutely seeing plaintiffs taking cases to trial. Even with a policy limit offer. And so we are definitely seeing that. And I think the question ultimately is like, why, right? I mean, you're not going to get blood from a turnip. So why? I think that they are aware of the dynamic that is existing and the context in which they're taking these cases to trial. And on plaintiff's counsel, if I'm plaintiff's lawyer, I want to get as big of a verdict as I possibly can to slap up on my next billboard, right? I want to generate as much press as I can, because I mean, the chances that I'm going to represent this same guy who, broke his neck or fractured his knee or whatever the case may be is pretty slim. But whatever I get in quotation marks on that guy's case, I can use as publicity and as marketing for the next 100 cases that I'm going to get. And what's really concerning about that is that, we track these nuclear verdicts. They're in the news every other day. And what's concerning is that jurors are seeing those. I mean, your future plaintiffs and claimants are seeing those numbers too. So their perception of what a realistic and appropriate settlement offer is very skewed, but jurors are seeing those numbers too. So even when we know that most of them, come back on appeal, you don't hear about that, and the damage is already done, right, for your jury pool. So, I mean, that was a very roundabout way of saying we are absolutely seeing that. I don't know that there's, more insurance equals more, enticement to pursue litigation. I don't know. I mean, I will say that I think, the chances if you get hit by somebody, on the street and on the side of the truck is some big company's name like Walmart, you're probably going to be more apt to pursue litigation in that sense, because you have in your head that there's deep pockets there. So I think that is probably at play, but absolutely plaintiffs are taking cases to trial even after that kind of a settlement offer.
Yeah, and Ashley, we'll maybe talk about this when we get to the end about mitigation or plans, but there is a trend that we've seen that we have. I know I've no firms that are doing this, that rather than having a construction firm that's got their logo emblazoned all over the truck, it's like, no, they're just driving white unmarked trucks, because the studies seem to indicate that if you get hit by a car that's clearly a commercial van or truck, you're more likely to get sued versus something where it's initially just a white truck. You really don't know anything about it.
Yeah, I think that's absolutely, I'm not surprised to hear that. I mean, that tracks what I perceive to be the reality of things too. So
thanks. Tim, thanks for the question. Again, if you wish to submit a question for Ashley, please look at the bottom right-hand corner of what you're looking on LinkedIn. There you see my face next to the oval where it says add a comment. Please go ahead and type in your question and press enter, and I'll bring it to Ashley's attention. So Ashley, part of this too is I can kind of talk a little bit more about how we got this point. It's clear that certain states have more of a litigious environment than others. And, having just got back from, Florida, from a recent trip, it's amazing amount of billboards you see everywhere left and right in Florida. And it's been a tough state for places to get commercial auto insurance, and Texas is not too far behind it. Can you maybe comment as far as what if anything, as part of this growth in nuclear verdicts has anything to do with because everything's done at state levels, how certain states have maybe been more favorable to this nuclear verdict than others?
Yeah, I think that's, I just got back from Georgia, and so I saw absolutely the same thing. I mean, on my way to the airport, from my hotel in Atlanta, which was not a very far drive, I counted them, and there were like upwards of 45 billboards. It was like, holy smokes. So, ATRA releases every year their judicial hellhole report, and that's kind of what we're talking about, right? When we're talking about, you know, jurisdictions that are more prone to plaintiff-friendly results, and that's really what we're talking about is judicial hellholes. And what's interesting is, like, there are kind of those hot button or known jurisdictions that are associated with higher payouts just because you see them more often in the news. Georgia, Cook County, LA, Florida as a whole, Texas as a whole. I mean, there are just some Philadelphia is another big one. Some really jurisdictions that we know. I mean, LA, downtown LA is referred to as the vault because if you walk there as a walk there as a plaintiff, you're going to walk out with money because it's like a bank vault. So we know that there are certain jurisdictions that are definitely associated with higher awards. And I think that is still the case. But what I will say is that in tracking where these verdicts are happening and just sort of being aware of, the practice areas that are more at risk, as well as the areas that are more at risk, I think it used to sort of be that if you weren't in one of those known judicial hellholes, you didn't really feel the need to worry quite as much, right?
Yeah.
But the reality that we're seeing is it doesn't really matter where you are. You can still get hit with a nuclear verdict. I mean, we've got nuclear verdicts coming out of Oklahoma, Iowa, Wyoming, like places that are traditionally, more conservative, politically conservative jurisdictions that you wouldn't think, it's going to be just free money, monopoly money time, but they're happening everywhere. So I think, part of it is, and I don't know the data on this, I don't have this information, but I would be curious to know, if you analyze the number of nuclear verdicts that are delivered in a specific judicial hellhole compared to the number of cases that are actually filed, what does that look like compared to a state, that's not considered a nuclear verdict? What are those statistics? Meaning, is there a greater percentage of cases that are filed in those jurisdictions that are judicial hellholes? So maybe it's not really a fair barometer to judge it by. So I don't know. I mean, I don't know the answer, except for that I will say it can happen anywhere. There are some known places that are traditionally viewed as and continue to be viewed as plaintiff-friendly jurisdictions, but they're happening across the country.
Are you seeing amongst the trend, I think at least part of this answer, as far as certain industries are more susceptible to these nuclear verdicts than others? And I imagine commercial trucking's at the top of that list or pretty close to it. What other industries are you seeing where this is being more of a problem than others?
So trucking, transportation, huge. Medical malpractice, huge.
Okay.
Sexual abuse and molestation, big. EPL, employment, is also really big. There was recently a $25 million or $30 million verdict that was delivered for a defamation claim. So really, I mean, like I said, it kind of runs the gamut, but those are the top three, I would say, is trucking, med mal, and maybe SAM, abuse molestation.
Yeah, and when we're talking, just to clarify, people watching, we're talking employment practice liability. We're talking wrong hiring or firing, sexual harassment, that kind of thing in the workplace, correct?
Right. Yep. And retaliation, anything like that. Yeah.
Okay. Yeah. So that can almost be almost any industry, because that's attributable to almost
right. Exactly.
It's not exclusive to construction, whereas it is to medical, hospitality, whatever the case may be. So. One area I want to talk to you real quick, and we're talking about how we got to this point, and this is maybe a relatively more recent trend, but you brought this up on the panel in Vegas, which I was kind of I heard about it, but then you talk about the next level really kind of blew me away. Can you walk us through the concept of this cottage industry, for lack of a term, where we have private money, whether it be private equity or whoever, is funding a lot of these efforts and then as a result to get higher return on their money than not investing. Can you walk us through that process?
Yeah, so that is a massive industry that is pretty much completely unregulated. There are third-party litigation funding companies that are coming in as a non-party, but funding a party, usually the plaintiff, funding the plaintiff's efforts in the case in exchange for a cut of the end result. And so their goal really is to drive up damages and drive up the verdict as much as they possibly can. What's scary about it is because it's completely unregulated, most states, there's no disclosure of that to jurors, which to my mind is crazy because one of the things that jurors in every case have to consider is bias, credibility, motive. And don't you think they need to know, they deserve to know who the mysterious Oz is behind the curtain that's driving the show? They deserve to know that. But in most states, they are precluded from being given that information. The other really scary thing that is happening is these third-party litigation funding companies can be companies that are foreign entities. So that doesn't sound too bad. That sounds kind of innocuous, except for when you think about what that looks like in practice, which is, this is a hypothetical. If there was a Chinese company that was bent on taking down some big American company like a Walmart or a Target or a Kmart, I don't know that Kmart's so big anymore. Sorry, Kmart. Some big company.
Sure.
We still have Kmart's here, but I think we're one of the few places. If they were really bent on trying to take down an American company for their own interests, they could just fund litigation against that company. They can tamper with the judicial process. That speaks to, I think, and again, as someone who's very concerned with justice and fairness, a real ethical problem for our judicial system. And I think it's a national security issue because there are shadow companies that people don't know about, and they don't know where they're based or what their motivations are, tampering with, and in some cases, outright controlling the results of litigation, which impacts all of us. So that is a massive industry that is just, I mean, there's like really no regulation.
I think
some insurers are, oh, go ahead, sorry.
No, I think it's a very extremely valid point because especially looking in this current environment with, just especially where certain, countries, there's no difference between the ruling party and the business, where, especially you have now artificial intelligence and cyber espionage and actively looking to steal, foreign interests and information. There's also the same thing to be done from just like good old, dirty politics, for lack of a better term, to take out a foreign competitor by suing in open court and using your money to help do that. No, I think when you said that on that panel, that really got like, wow. I don't think people understand the potential for abuse that can be used by nation states to really hamper Western business wherever, as far as competitiveness, and take out one of your opponents and do so by having their own citizens suing them. I mean, I think that's a very valid point. I never really thought about it until you said it on the panel.
Yep. Yeah, it's terrifying. I mean, it's terrifying. I mean, and again, this is to my point that I think if everyday Americans knew what was actually happening in courtrooms across this country, they would be mortified. I mean, it's just really scary and really wrong. So really biased, but that's just because I've spent a lot of time researching the problem. So,
well, we got another question from Mr. Fandry, which I appreciate, which is very much in point. Outside of MedMal, are there any promising tort reforms efforts right now? Damaging limits? What about other things not typically thought of as a tort reform, e.g., up the ladder for workers' comp being an exclusive remedy? That was obviously that kind of ties in. So we've had this problem going on since maybe 2009, and it's obviously going across the states. And like here in Texas, we did MedMal reform practice to limit damages. Is there any sort of effort going in any states? Have any states done this or in the process to try to cap damages, if that's a good idea? Or, I mean, what is being done from a legislator standpoint in any of these regions to try to maybe put the kibosh on some of this?
Well, I mean, I think it's always on every legislative agenda across the country. I mean, I think that it just fails very frequently. I mean, that's just the reality of it. Florida recently, last year enacted a sweeping tort reform bill And I think it's probably a little early to see the actual impacts of that bill, but it caused the plaintiff's bar to mass file thousands and thousands and thousands of cases to try to get it in under the effective date deadline so that they could still take advantage of the previous law that was in effect. So I think, I mean, I'm not holding my breath for tort reform to be the answer, is the long and short of it. I think it would be fabulous if we could enact some tort reform efforts, caps on damages, caps on non-economic damages, something, which some states have. But, you know, I don't think that that's going to resolve the problem. And I think it's going to take a very long time for that to even move through most states to the point where it can become an enacted law.
So, okay, so that brings us to maybe the kind of where we currently stand. So obviously with you and your group, you're very proactive as trying to educate and inform people about, you know, nuclear verdicts and what maybe could be done to, you know, never get to that point or what to maybe mitigate it. So what are some of the best practices you would advise to people who might be on the short end of the stick or looking at the end of a lawsuit? What are some of the things that firms can be doing now to think about, okay, we need to do this to not even get to this point, but then even if we get pulled into, how do we react to it? How do we, you know, what's our plan? What's our plan of attack?
Yeah, so I think, you know, we talk a lot about the psychology behind nuclear verdicts and juror psychology in general. We know that the number one driving factor behind nuclear verdicts, because they happen across every industry, they happen to experienced defense counsel, experienced adjusters, they happen in jurisdictions everywhere in every type of case. We know that what they all have in common is juror anger. So we know that the number one way, in real life outside of trial or the legal world, the number one way to defuse anger is to validate it. And so that doesn't mean just agreeing and saying, yeah, you're right. It doesn't mean stoking that anger. It doesn't mean fueling that anger. It means acknowledging the presence of that anger and acknowledging the legitimacy of that feeling. It doesn't mean agreeing with it. And so we have developed a set of nuclear verdicts defense methods that we use in every single case. And this is what we teach on across the country. It's applicable to insurers. It's applicable to their carriers. It's applicable to underwriters because it can help inform you what you should be writing for and what risk factors exist. And so we really try to orient everyone in the industry toward A, acknowledging that this is a problem, B, communicating with each other as we're doing to talk about the problem and more importantly, to talk about the solutions, and then C, really being proactive in addressing what is going to make a jury angry in this case. Even if the case never makes it to trial, being able to work a claim up with that in mind and gather that information to effectively use the defense methods, which I can talk about, is going to be really, really helpful and really huge.
So you broached it, so let's bring it up. What are some of the defense mechanisms you would suggest or advocate for?
So we have 4 nuclear verdicts defense methods, and we teach full days, weeks on each of them. So I'm not going to be able to go very in depth on each of them.
Sure.
So I'll give you sort of the high level view.
Yeah.
The first one is accept responsibility. We accept responsibility for something in every single case, even when we're going for a defense verdict. Which is very uncomfortable for people, but it works and it has psychological benefit. The next one is that we personalize the corporate defendant. So we humanize our client by putting a human face and telling a human story behind this corporation, which really works to counter that corporate identity effect that I talked about earlier. The next thing we do is we give a number. Plaintiff's counsel is going to be delivering their number and telling the jury what, quote, this case is worth, which is always funny to me because I'm like, there's no sticker price. The law says there's no sticker price. There's no formula. If there was a formula or a sticker price, we wouldn't be here. We wouldn't have jurors. But they deliver their number right out of the gate. It's huge. That's the other big change. They don't just go for anger anymore. They give a number, and it's usually a big number because they know the only way to get a big verdict is to ask for it. So we give a defense number in every single case, even when we're going for a defense verdict. And that is, I think, the hardest. I think that's the method that people struggle with the most, because it feels like, well, am I just confessing liability, or am I setting a floor? What if, can I give a number while also looking for a defense verdict?
Sure.
But the science shows that your chances of getting a defense verdict actually increase when you give a number, which is, I think, pretty shocking.
Yeah. And I want to come back to, and there's a fourth, because I definitely want to come back to that one as far as give a number. Yeah.
Yes. Yeah. The fourth one is to argue pain and suffering.
Okay.
Non-economic damages, pain and suffering, that is the biggest component of nuclear verdicts. And I think, the reason for it is like, there's no formula. It can be based on anything that the plaintiff's lawyer decides to base it on, right? So they get up there and they make these really creative arguments about, what the Mona Lisa is worth, or how much Patrick Mahomes gets paid as a quarterback. And they tie it to like, a certain number of hours in a day that's based on the life expectancy and how much suffering, and certainly he deserves at least minimum wage. So they do all these creative things to make it seem like a legitimate number, and it adds up to some astronomical number. Pain and suffering is where the money is for plaintiffs, and they know that. And so we argue pain and suffering. There are two prongs. We argue the impact of the accident or the incident on the plaintiff's life, which is not just surveillance video. It's actually getting to know the plaintiff and getting to know what it can actually still do. And we share that with the jury as sort of a hopeful view toward the future of what this plaintiff's life looks like, and to counter the doom and gloom story that they're getting from the plaintiff's lawyer. And then the second prong of arguing pain and suffering is arguing the impact of money on the plaintiff's life. And that is really that giving a number and arguing pain and suffering go really hand in hand, because in order to deliver a number, you have to show the jury what it's based on. Like it has to be tied to evidence, and you have to show them that the number that you are proposing is going to make the plaintiff whole. Nothing more, but nothing less. And so we really try to get creative in terms of like, what can this number actually do for the plaintiff? So that requires us to get to know, like, how do you spend your time? What are the most important things to you in your life? What are your hopes and dreams and passions? What keeps you up at night? What are your biggest financial stressors? For millennial plaintiffs, do you have any outstanding student loan debt? These kinds of depot questions and questions asked during the course of the case through discovery, and then eventually when the plaintiff is on the witness stand in trial, help us to paint a picture of what this number that we're giving the jury is actually going to deliver for the plaintiff in concrete terms. And that also has the added benefit of reminding the jury of what the value of a dollar actually is. Because if we find the whole family together for an annual vacation at Disney World, that is everything that they want and need in their lives, and we will fund that. That kind of contextualizes what our money, what our offer, what our number can actually do for the plaintiff in a real way.
Awesome. Hey, we're getting close to time. And then again, if anybody has a question for Ashley, please go ahead and type it in the bottom right-hand corner. You see my photo next to the oval. It says add a comment, type in the question, press enter, and I'll bring it to Ashley's attention. Ashley, before we get towards the end here, I want to circle back though. There's a point as far as number 3 says, give a number. What is in your strategies, where does participation or / cooperation with the insurance carriers come into play? Because obviously that's where insurance is, and they have a sign, they have to sign off on what amount you want to be giving. How does that come into play?
So we are as proactive as we possibly can. I mean, we're often parachuted in to deal with, for lack of a better word, messes. But as soon as we can have those proactive conversations to start putting together the information that we're going to need in order to determine what the number should be, we have that conversation as early and as often as we possibly can, so that if they need to run it up the chain and get authority, we have plenty of time to do that, right? Our rules for giving a number, you give it early, you give it often, and it never goes up. So that means that you can't be coming up with what your number is on the night before trial. You have to have come up with what your number is based on the evidence in the case, based on communications with the insurer, based on what is reasonable, and based on the other things that I've talked about as far as pain and suffering goes. So then when you walk into trial, we deliver it as early as voir dire if we can. There are some jurisdictions, that's jury selection. There are some jurisdictions that don't allow you to give a number during jury selection. But because we've had those conversations and we all know, the whole team knows going in what our number is going to be, we give it as early as we possibly can, and we come back to it time and again. Now, I'll say that we prefer to give a range. So often it will look like, in voir dire, it might be like, oh, wow, I just heard plaintiff's counsel is going to be asking you for millions of dollars. I mean, Ms. Punt, if the evidence in this case showed you that an award of $300,000 or less is the appropriate number, would you be willing to deliver that kind of a verdict? Ms. Smith, if an award of $300,000 or less was what was supported by the evidence, would you feel comfortable with that? And then, during the course of the trial, you may come back closing and say, the number is 120,000. And then we've still delivered on the range that we told the jury from the beginning. And it gives us a little bit of cushion. So we know, like, if we really destroy one of their experts, their life care plan expert on cross, or, we really have a really good argument for silent witnesses, the lack of medical treatment, something that might deflate the number, we have some cushion to bring it down even lower than what we told the jury at the outset without looking like we're backtracking. But those conversations have to happen really early and be very proactive, communicative conversations so that everybody at the table is aware of what the number is going to be. And the adjuster can, like I said, run it up the chain and get authority to do that if that's necessary.
Got it. Wow, Ashley, this has been a phenomenal conversation, and we could keep going on here for hours. I've only got so much time.
I was going to say, it's clear that I have a lot to say about this. So.
No, absolutely. It's a big topic, and it's one that's deserving a lot of attention. That's why I think just looking at the numbers here, this has been one of the most watched shows live I've done. So I think it goes evidence as far as the demand out there. So, and obviously, Ashley, before we let you go, just want to spend some time. They say, obviously you're very busy, you're very knowledgeable in this area, you're very passionate in regards to dealing with nuclear verdicts. But when you're not working, what are you doing?
Oh, it's a good question. So I have two small kids and they occupy most of my time. My daughter is 3, my son is 1. And so when I am not geeking out about nuclear verdicts, I'm chasing toddlers around. But I also, we try to go hiking and camping as much as we can. And I dabble in photography. So a couple months ago, I guess it was last year, I decided I wanted to buy like an actual nice camera, even though I had no clue what I was doing. And so I've taken some classes at community college to kind of figure out how the whole thing works. And that's my creative outlet outside of work. So, yeah.
So you live in Colorado, you skier?
I'm not. I'm a bad Coloradan. Yeah, no, I'm not. I did when I was a kid, and then I left Colorado when I was 17, and I didn't move back for many years. And, ski passes are insanely expensive.
I know.
I'm like, with 2 tiny humans, how likely is it that I'm going to be spending hours in the car driving to a ski resort? Not likely. No, I don't ski. I don't snowboard. I'm a bad Coloradan, but I do hike and I do camp. So
that's a great place. No, it's, as someone who lives here in Texas, I'm sure most of you guys get angry about all the Texans that show up in the summer and the winter. But no, Colorado it's a wonderful spot for both. I say I ski. I do my greens, my occasional blues. That's about it. But also summertime is a beautiful place to come, especially Telluride is my wife and I's my favorite spot to go to, both for winter and for summertime.
Oh, yeah, Telluride is amazing. There are so many great spots in my state, and greens and blues better than what I would be doing. I would be rolling down the hill. So you got me beat.
So obviously, if someone wanted to know a little more information about nuclear verdicts and trend lines, other than your own firm, obviously, in your book, and they should come to you. Any other resources, organizations that you would point people to, any books you specifically would like people to read to get better informed of what's going on in this marketplace?
I mean, really shockingly, Bob's book is the only playbook for the defense that I'm aware of, and really the only one that analyzes nuclear verdicts. We have a second book that's going to be coming out in the summer, actually, that we have analyzed 100. It's real. I mean, it's cool, especially if you're a data nerd, which I think most insurance folks are. They appreciate the data. So we analyzed 100 cases that went nuclear by reviewing and studying the trial transcripts and the closing argument transcripts, and tracking something like 70 or 72 separate data points to look for patterns, like what is actually driving these nuclear verdicts in practice. And they cover every state, every type of case. And the good news is that there are patterns, which is great, because if there's a pattern, we can break it. So that book is going to be coming out in the summer, and that is going to be fabulous.
What's the name of the book? Has it been determined yet?
Yep, it's Break the Pattern. It's Nuclear Verdicts, Break the Pattern.
Okay, awesome.
Aptly titled. So so be on the lookout for that one, because it's going to be it's really cool. And so what we're doing is we have a couple of cases that we've done some deep dive analysis on, and we're going to actually show you how, and show your counsel how to use the methods in a specific case. So we're kind of stepping into the shoes of the defense counsel in cases that went nuclear, and showing how the methods could have been used in those cases to defuse that juror anger at the heart of nuclear verdicts. So that one is going to be really cool. And then the only other resource that I would encourage folks to definitely check out is the American Tort Reform Association. As I mentioned, they do a lot. They issue white papers, and they issue studies on judicial hellholes that are really well researched, and they have really nice outlooks in various states. And you can kind of compare, like, what were the top 5 judicial hellholes this year compared to last year, and what trends are they seeing? And so if you're looking for just sort of like get your feet around the problem, get your hands around the problem, those papers are really good resources. And then we have on our website also, if you're just looking for sort of like a caveat or anecdotal evidence, we have our nuclear verdicts tracker, which is on the Tyson Mendes website. Which it's not exhaustive. It doesn't have every nuclear verdict, but we try our darndest to keep it updated. And you can sort by keyword, by state, by practice area, by date, to kind of see, like, recent nuclear verdicts. And I think we have it updated as of last week, and then we'll be updating it again this week, because there have been like 3 more this week that we need to include. So the hits keep on coming. So there you go. Ashley, thank you so much for your time. This has been a great conversation. I know the audience has really enjoyed this. Obviously, if they want to find you, they can reach out and find you on LinkedIn. Again, please do.
Thanks for joining us, and greatly appreciate your input.
Thank you. Thank you, Brian. This was a great conversation. And thank you to everyone who tuned in. I really appreciate it.
You bet. So everyone, that's the first episode of the year for Risk On, Risk Off. I thought it was a good one too. Nuclear verdicts are not going away anytime soon. And it's an issue that's perplexing every industry. And if you're sitting here watching this thinking, oh, how does that bother me? Well, know this. Nuclear verdicts are costs to a company. And whether it be the insurance company's paying for, or it's coming out of the pocket of a company, it's a cost. And companies pass forward that cost onto the consumers. So it's a big reason why you're seeing a steady upward tick in insurance prices. Specifically, if you're in the commercial area, you're seeing your upward pressure on the GL, the umbrella, and the excess lines, because that's where the nuclear verdicts come in. Once they get past the umbrella line, gets to the excess tower, that's when those carriers start getting hit, and that's when those costs get passed on you, the consumer. Or what you're seeing is that some carriers are flat out leaving industries, and it's making it very difficult for certain industries to get insurance in the first place. So there's a cost associated with this. It is an interesting point, because you sit and talk to people when I was at this conference. If you say, what's the right number? Well, I'd ask anybody, well, what's the right number for me to put a bullet in your spouse, your kid's head? I can't come up with that number. And it's a difficult task, but the pure fact of the matter is these numbers are large. They're getting increasingly large. And it's making it very difficult for businesses to do work in certain areas because they can't get the insurance. So this is a little taste of the type of topics we try to cover here on the show. If there's a certain individual or topic you'd like to see on this, or if you want to be on it yourself, please reach out to me or post me a note on LinkedIn. And love to get your ideas and suggestions, and obviously appreciate any connections or introductions you can make on my behalf with any potential guests. And going forward, you can always find these videos on my YouTube channel. There's a dedicated playlist for Risk On, Risk Off. And going forward, guys, I hope you enjoy this and hope you see you back the next time. Talk soon.